Hello again. Welcome back. Mr. Shaw here again. Last video I had like a sneezing fit, so that's why you noticed I kept pausing and then like restarting. So I apologize if that was kind of choppy there for a second. I don't know what happened. Let's get to it though. We're going to go ahead and continue on. This video is probably going to be as long as it needs to be for me to finish this PowerPoint. So let's get right to it. So now we're going to transition into limits on the Supreme Court. Again, last video we talked about the judicial review power of the Supreme Court. Again, granting them the power to grant, to declare laws or acts unconstitutional. Again, that is the most important thing to remember about the Supreme Court. But there's a couple other things that are going to be limitations on their power. So first off, the executive branch has to enforce the decisions. The executive branch could literally just choose not to enforce something that the judicial branch had said or had declared. If they had declared a law unconstitutional, but the executive branch didn't enforce that, again, the Supreme Court the judicial branch relies on the executive branch for that. So, for example, after Brown versus Board of Education, had the president not stepped in and made sure that every school was desegregating, the Supreme Court would have been completely helpless, to make sure that everybody was doing it. So that's one good example there. Also, Congress can get around a court ruling by changing the law deemed unconstitutional. So if there is a particular part of the law that was declared unconstitutional, again, Congress can get around that by literally just changing whatever tiny part of whatever part of the law was deemed unconstitutional, or they can change it into something that doesn't really look the same at all, but still gets the same kinds of thing done. So that's one way Congress can get around that. But again, we've learned about the lawmaking process. We know that it is really hard to get a bill to become a law. So that's really important to note that yes, the Congress can do that, but that is very difficult. And again, the court can only hear and make rulings on the cases that they receive. They cannot really request to hear a case unless they have jurisdiction. So if there were judges that there are justices of the Supreme Court that really wanted to hear a case on, say like LGBT rights, but nobody had come forth with a case like that, they would be powerless to fix that situation. So that, again, that's just another kind of limitation, another check on their power. Again, we talked about I mentioned the caseload a little bit earlier in the video. Again, they're going to meet for about 9 months a year. The first Monday in October would start the 2015 term. They decided that they were going to meet then, starting in the 2015 term. And how they accept cases is that they're going to accept a case if 4 of the 9 justices agree to do it. Now that's important. 4 of the 9 is not a majority. So if 4 of the 9 justices wanted to hear a case, they needed to convince at least one more judge that something needed to be overturned. So that's really important to note. So again, you only need 4 to hear a case at the Supreme Court, but you need 5 in order to overturn a ruling, or you need in order to get a majority. Again, if they agree to hear a case, that it goes on what's known as a docket, or a case, just a calendar, and again, that is kept up by the magistrates and the other people that work for the Supreme Court to make sure that the court is running smoothly and efficiently. Again, and I mentioned the selecting cases. Again, here are again just a selection of years throughout the last, let's say 60 some odd years, 60 to 70 years. So like in 1950, there was 1,181 cases that were appealed to the Supreme Court, and they only ended up hearing 125 of those. Okay, flash forward again 58 years, 7,738 cases were appealed to the Supreme Court, and they only heard or reviewed rather 83 cases. So again, you notice that the number of cases that they've been reviewing has gone down steadily. But again, it's gonna vary from year to year, and again, they're only going to have jurisdiction in a very limited number of cases, ones that deal with the Constitution or federal law, stuff like that. So again, it makes sense that they are only seeing a small number of cases because those are probably the only cases that are really important. Most of the time, too, guys, like the cases that they hear are controversial. So like they're not going to really hear a case about something that is not like going to affect a lot of people. Something that is like about one person, that's not really for the Supreme Court. Now, again, in some cases it will, but again, most of the time it's going to be about a broad range. So, for example, like in Brown v. Board of Education, there was, people were suing the Board of Education for segregation, saying that it was, or they were trying to, they were trying to continue segregation, and like so. Anyway, that went to the Supreme Court. They ruled that Plessy versus Ferguson was unconstitutional. Separate but equal is unconstitutional, and that again that affects the entire race of African Americans. Okay, and now that they can go to school, the same schools that white kids are going to, and get all of the benefits that from that as well. Anyway, again, so the number that they hear is very low every year. Again, it's kind of like the same comparison as the number of bills presented to Congress every year and the number of bills that are passed into law. Again, it's the same kind of thing. So again, as I mentioned this a little bit earlier, again, which cases reach the Supreme Court. Again, these are going to be ones that raise very important policy issue questions. Again, most of the time dealing with federal or state laws that could be deemed unconstitutional. If the lower courts have reached different conclusions on an issue, they may review it to define the law. So, for example, let's say the district court ruled in favor of somebody, and then the appellate court, the appeals court, ruled against the plaintiff. That means, again, that like the two courts disagreed. So then the Supreme Court could look at that to help define the law to make sure that that kind of disagreement doesn't happen in the future. Again, for the Supreme Court, again, just like the appellate court, the attorneys are going to present legal briefs for the Supreme Court to review. Again, those are just written statements, sometimes spoken statements, and they are, and as I said, they're also going to present oral arguments. So they will present the briefs for the Supreme Court justices to read, and they will also present oral arguments in front of all of 9 justices, or in this case 8, as we currently stand. The writ of certiorari is an order that the Supreme Court issues to lower courts requesting the latter send it the record of the case in question. All this means, guys, is that if you are granted this writ of certiorari, you are allowed. Then the Supreme Court is going to take over your case. Okay, that is, again, once you are granted the writ of certiorari, again, your case then goes to the Supreme Court. Again, anyone can petition the Supreme Court to issue a writ, and again, that was kind of decided in Marbury versus Madison. Again, that was Marbury he issued a writ of certiorari trying to get the Supreme Court to hear his case. It was granted. And then, again, like I said, 4 of 9 justices have to approve the writ. So a writ of certiorari is literally just the formal name for the Supreme Court to hear a case, or to review a case. Again, the opinions are really important on the Supreme Court. Again, justices are going to discuss the case in a conference. Again, it's kind of like a jury, but again, they're just going to they are just going to sit down and and discuss the case, kind of talk it out, and then they are all going to have their own opinions. They can provide written arguments. They will provide oral arguments as well, all while in this conference. And the Chief Justice, if he is in the majority opinion, will write the court's opinion. So if he is in the majority, he has the ability, he has the power, since he is Chief Justice, he will write out a whole long statement about the Supreme Court's decision. Okay, and again, they do that in every single Supreme Court case. Okay, so you can look up like old ones, and we'll look at some in class of like Brown v. Board of Education, Plessy versus Ferguson, and all of these judges have issued a statement that is known as the majority opinion, and that majority opinion is supposed to be used by all of the lower courts later. We also have, again, we have two different types. Again, we have the majority opinion. We have a concurring opinion that can be written by a different justice of the Supreme Court. A concurring opinion is when a justice agrees with the court, but maybe has different reasoning. Okay, again, this is just, and again, that differing opinion doesn't have to be used as precedent. Again, like the majority opinion is what is going to be used as precedent. Again, the concurring opinion is more, it's like optional for different judges if they want to present that as well. And then we have dissenting opinion. These are written by justices who disagree with the court's opinion. So they are, again, they are in the minority. They voted against what the other justices voted for. A really good example is, again, this is not, again, this picture is, this is of the current court, again, minus Justice Scalia. But again, like say we had, of the 9 justices, say 7 voted for it and then 2 voted against it, you know, and then say one of the justices wrote a dissenting opinion. Okay, you can, like, that dissenting opinion can be used later as a reasoning to overturn a case. So the best example is in the Dred Scott case. Again, he was voted 8-1 for not being human, not being an actual human being. And that one dissenting opinion was used later to kind of not in that Brown v. Board of Education, but again, well, kind of. I mean, they addressed it, but anyway, that is when they created the case that overruled Dred Scott. Okay, the dissenting opinion was used as the basis for the new majority opinion. Okay, anyway, I understand that that's kind of confusing. So what I'm going to leave you with, I'm going to say, okay, the dissenting opinion can be used later if times change. So, for example, with Dred Scott, they declared that he wasn't human. Obviously, we know that is not the case. Okay, so later on, when times had changed, times had kind of caught up to everybody. Everybody, was like, okay, everybody should have the same rights. So they said, okay, you use that dissenting opinion from Dred Scott as a basis for the new ruling that is overturning the old ruling. Anyway, hope you get it. We'll talk about it more a little bit later if we need to. So here are their reasons for decisions. Okay, again, the first one is just the law. Stare decisis, that is a Latin term that means let the decision stand. Okay, so what they're going to do, and it is the federal courts and federal judges' job to follow the precedent that other courts make. Okay, again, they want the law to be predictable. So that's what, again, so you're trying to follow precedent unless you think that the precedent is wrong, and then the Supreme Court would have to overturn that. Again, just like I had mentioned, the other one is changing social conditions. So Plessy versus Ferguson, like the one that segregated all social areas into, again, white areas and then black areas. That, again, the social conditions had changed, and then in the 50s, Brown v. Board of Education comes out, and that is going to say, hey, this is not right. The court back then was not right, and we are going to overturn that with our new ruling. There's 2 different types of legal views for judges to follow. The first one is judicial activism. This is where judges substitute their own political opinions for the applicable law. Basically, judicial activism is about changing something. They're trying to use their own power, their power as a judge, okay, to change a law or change something that they do not think is correct. Okay, so again, that judicial activism is about actively changing laws. Judicial restraint is on the other side of that. They are going to encourages judges to limit the exercise of their own power. The restraint is going to be about upholding the law and keeping the law consistent. And then judicial activism, like I said, is about kind of changing the law and making it go forward. Again, judges are going to be on both sides of that for any one of these decisions that we've been talking about or that we've learned in the past. And the last thing is just going to be their personal beliefs, what they believe, personally about a certain law, a certain situation, certain topic. Again, and their background is going to be very important in that. Are they Christian? Do they come from from the South, from the North? Do they was their family life like? What kind of lawyer were they? Anything like that can help influence their decision. Okay, I knew I said that this one was going to be as long as necessary. I think I'm going to go ahead and take that back and change it. And the last one will be about the Supreme Court justices themselves, and then just a few other odds and ends here. It should be a pretty short video. So anyway, catch you next time. Thanks for watching.